All right, chapter 20, transfer of title. This chapter is going to describe the four methods of title transfer. We're going to explain the process of the transfer of title of a deceased person's property, how that works as well. So the word title in real estate simply refers to the ownership of the land. There's no document in real estate called title. Title simply refers to the ownership of the land. And alienation is a transfer of that ownership, the transfer of title to a parcel of real property. This can be accomplished during your lifetime or after your death. It could be voluntary or involuntary. At death, it can be done voluntarily through a will, your last will and testament, or involuntary if you did not have a will, because the state will then get it by the process of escheat. If no heirs can be located and you died without a will, the property will revert to the state and they will get the ownership. Now, title to real estate simply means the right to or ownership of the land. So let's highlight that. And alienation is the transfer of title to a parcel of real estate. Okay. So a voluntary alienation can be done by a gift, sale, or exchange of property. The owners will use some form of deed to convey that ownership interest or partial ownership interest during their lifetime or by will to transfer voluntarily upon their death. Transfer of ownership to or from the government. You could give land to the government through dedication by dedicating the land. You're giving it to the government for a public use to be used as a street, school, or for parks. Or the government can give land to a private person through what's known as public grants. They're granting you that ownership of the government's own land. So let's do the highlights here. For voluntary alienation, dedication and public grant, this is on page 374. Involuntary alienation, title to property can be transferred by involuntary alienation without the owner's consent. Or when a person dies intestate and leaves no heirs, the title to their real estate passes to the state through the process of escheat, which we will go over that entire process and how it works. I gave you the basic rundown, but we'll go over it in a little more detail. Like if you die intestate without a will, who gets your property? Who can lay claim to it? That's an interesting topic. Let me know when you guys have all the highlights here.
Okay.
Okay. Yeah, everybody looks good. So once again, involuntary transfer without the owner's consent can be done by escheat. Your property can be taken by eminent domain. Through unpaid debts, you could be foreclosed upon. Through court action, a judge, you could have a partition proceeding where a judge would order the property to be split if physically possible. And if that's not physically possible, the judge would order the property sold. In the case where there's more than one owner and the other owner doesn't want to buy you out, and they don't want to sell either, are you stuck owning the property with them? No. You could take them to court and sue them in what's called a partition proceeding to see if a judge can order a property to be physically partitioned. And if that's not possible, they would order the property sold. And then both parties would have to get their shares according to their ownership. But it's a form of involuntary alienation for the one party who didn't want to sell the property. Adverse possession. Well, somebody's trying to take ownership of your property because they squatted on it for a long enough period of time and was using your property, and you didn't not remove them. So that's adverse possession. That's involuntary. Or by erosion, by Mother Nature. The wearing away of land by wind or water. Okay. And here on page 375 in the second paragraph is where you could highlight that what a partition proceeding is. Everybody able to find that? Locate that?
Yes.
Okay. We've seen this chart in another chapter as well, but it's actually from this chapter. What escheat is, or these are the different possible ways involuntary alienation can occur. A person dies without a will, no heirs can be located. The property, through the process of escheat, reverts to the state. If the land is needed for a public use through eminent domain and just compensation, the public or governmental agency, whoever has the power of eminent domain and is exercising it, would be the one that takes it. Non-payment of a debt secured by real property as collateral for the loan or for taxes or what have you. Foreclosure, a sheriff's sale occurs and the property sold to the highest bidder. Or through open, notorious, continuous, hostile, and adverse use of another person's property for a prescribed period of time as prescribed by law in your state. Adverse possession could occur, and the property would be taken by the adverse possessor. But this process is not automatic. It must go through the court system, and that is known as a suit for adverse possession or a suit to quiet title. So once again, for page 375 on the second paragraph, partition proceeding, one co-owner seeks to force another to sell or to divide or sell the property. And we've seen this in chapter 6, the easement by prescription and how that works. And here are the highlights in chapter 20, which we didn't skip forward and highlight. We are in chapter 20 now, so we could highlight it here on page 375. Adverse possession is another means of involuntary transfer. An owner may lose title to another person who has some claim on the land, takes possession, and most importantly, uses the land. In New Jersey, a person may acquire title by adverse possession through the continuous, open, notorious, hostile, and exclusive occupation of another person's property for 30 years if it's improved lands, or 60 years if it's unimproved woodlands or wetlands. After that time, the user may perfect the claim of title to the land through the legal process known as adverse possession by bringing a court suit to quiet title. And through the process known as tacking, continuous periods of adverse possession may be combined by successive users, enabling a person who has not been in possession for the full amount of time required to establish a claim of adverse possession. The process is not automatic. It does need to go through the court system to perfect this claim. Adverse possession is not possible against publicly owned property, though, only against privately owned land. So, knowing that, Once an adverse user's established title, the former owner has no recourse. So to prevent such loss of title, every person having the right or title to real property must inspect their property at least once within every 30-year period and take action against any adverse claims by adverse possessors. And then we have that inverse condemnation. You're not going to get this on exams, but it is good to know. It could come in handy sometime in your careers. Property owners who feel that new government requirements, they put all kinds of government rules of how you could use your property in place through zoning laws and restrictions and environmental laws and restrictions on property owners, that they could burden the property to the point that it can't really be used, or they devalued the property. A property owner doesn't have to stand for that. They could seek damages for money to be reimbursed for that through what's known as inverse condemnation. So the easement by prescription, once again, is when someone's used another person's property for a period of time as defined by state law. An easement by prescription may be claimed. The claimant's use had to meet these requirements, even though these requirements aren't written into the statutes themselves. It had to have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. That's basically what hostile means. Additionally, the use must be visible, open, and notorious. Okay? It has to be obvious you're using their property, not that you're just sneaking onto their land in the middle of the night, or you got an underground doggy fence buried around the perimeter. It has to be obvious that you're using the property so that the owner can see it and then not take any action against you. Then you can make that claim. If they give you permission to be there, well, you can't do anything. You can't claim ownership. So once again, it's 30 years for improved lands and 60 years for unimproved or vacant woodlands or wetlands. And any owner can halt the process by specifically granting permission for use, or take legal action to remove any adverse possessor, or by cutting off their continuous use, thus resetting the time clock every time they do that. All right. But they give an example here. The owner of a shopping mall or plaza often closes off an area one night a year to avoid any possible claims from the public that the public has gained some sort of an easement. You guys familiar with Rockefeller Center in New York City? That's where they got the ice skating rink. During certain times of the year, they block off certain areas of that park. It's not a public park. That's on private property, the Rockefeller Center. And so they block off certain areas different times of the year. So every year it resets that time clock. Certain part of the year, it's very famous because it's known for bringing in a Christmas tree, and they block off that whole area by putting up a Christmas tree, right? They've been doing that for a reason, to prevent the public from claiming that there's some sort of public easement that they could lay claim to. And that's ever since the Rockefellers owned the property. Since then, they've sold it to a Chinese company. So some, Chinese government owns all Chinese companies or has an interest in them. So it's not owned by the Rockefellers families anymore. All right, now through tacking, you could add on possession of one party to another to reach that prescriptive period. And legal action must be taken to perfect the suit for adverse possession. Okay, so let's get to the nitty-gritty now. We went through those pretty quick because adverse possession we went through several times already. So I kind of went through that one kind of quick right there. Now, transfer of a deceased person's property. How does that go down? How does that work? Well, title, that's the ownership. It's just a word that means ownership. So there's no document in real estate called title. When somebody's alive, we use a document called a deed to transfer the ownership when they're selling the property or giving it away, whatever. However they're disposing of it during their lifetime, it's done through a deed to convey that interest. When you die, your will, also known as a last will and testament, is the document used to transfer one's property after their death. A transfer of title by will is known as devise. And the devisor is the one who is leaving you their property in a will. And the devisee is the one who's named in the will to receive the property. And testate just simply means you prepared a will to devise, explaining how to devise your property. Okay? It states how to dispose of your assets after death. And keep in mind, a will has no power until after you die. An owner can rewrite their will many times during their lifetime as their possessions change. You should update your wills periodically throughout your lifetime if you sell a house or what have you, explaining who you want to get what. Okay, you know, situations may change, the people in your lives may change, some people may die, other people. So you should revise your will periodically to update it. Now, when you update it, you should date the will. So wills usually start off with some kind of a wording saying, this is my last will and testament, and shall cancel all other previously written versions of the will. Okay, you should have your name, your social security name, number, your name on the will. You should name somebody to be the executor of your will or executrix. That'll be the person in charge of making sure that close person to you that you trust to make sure that your final wishes are carried out. Transfer of title by descent takes effect only after you die. So your will has no power as long as you're still alive. It only takes effect after you die. When you're alive, you could still sell any assets you have. You could sell the property through a deed, using a deed. And every state has their laws of descent and distribution specifying who can inherit your assets upon your death when you die intestates, meaning without a will. It's very important everybody has a will, especially if you have children or family members still alive. It's very important that you have a will. It could lessen the problems of complications, and it could ensure that your assets will go to who you want them to go to. I know nobody wants to think of their mortality. We all think we're going to live forever, but listen, you could step off a curb and get hit by a bus and die tomorrow. It doesn't matter your age. I know we all think, especially when you're younger, your youth, you think you're invincible and you'll last forever, but, you know, people die in car accidents, they get hit on their e-bikes, you know, unknown illness can strike you down. Who knows? It's God's will when you're going to die. You know, how long are you going to be around? So we don't know. So you really should be prepared and have some sort of a written document. You know, I was always teaching these classes and I never had a will. And I'm like, I should take my own advice. So, you know, after a class that day, I took a blank piece of paper and I wrote a will. I just, you know, you write down your name, your basic information, you try to say, you know, you may not account for every single asset you have, but try to divvy it up, you know, your money, your bank accounts, your car, any real estate, and then any other personal belongings or assets, whether it's tools or jewelry or your shoe collection or whatever it is, you know, your computers or everything else. You could just write it as, to be covered as, who gets it, how it's to be divided, you know, be specific so that things cannot be misinterpreted, okay? And then, very important, make sure it's someplace where people can find it. If you got a will but nobody can find it, nobody knows you have a will, You know, it's a short period of time from the time that you die for them to be hunting through all your stuff trying to find a piece of paper uh, that they don't know if you even ever created. So you should have all your important papers like in a folder labeled important documents, you know, or open in case I die, something obvious that people can find, put it in your safe as long as somebody else has a combo to the safe, but put it somewhere. That document should be somewhere where people can get access to it. Okay. You may not want them to see who you're leaving what to while you're still alive, but put it someplace where it can be located. Sit it on top of your safe. Okay. Um, so intestate means you did not prepare a will. And it's involuntary because you don't get to specify who gets your stuff if you died without a will. If you died testate, meaning you prepared a will, well, that's voluntary because you're specifying who gets your stuff after you die. Okay? You may want to consult an attorney about making a will and your options, or you could get things like, I don't know, Susie Orman or Quicken Willmaker, or there's plenty of software out there that can guide you through the process of making a will, and even a living will, which dictates, who's going to make important medical decisions for you. Like if you're in a living coma or something like that, do you want them to pull the plug or do you want them to keep you alive as long as possible? Things of that nature as well can be addressed. And if you got kids, who do you want to take care of your kids after you die? And if your spouse is nowhere around, who can take care of your children? You may want to specify somebody to take care of your kids afterwards. Okay. Okay. So transfer of deceased person's property. Intestate means you did not have a will. Testate means you did have a will. So here's where you can highlight that. And also that wills must be probated. And then I wrote an explanation what that means here, meaning all debts must be paid, especially unpaid taxes or claims from creditors. Probate also will determine the validity of the will and that the people named in the will who come before the court or to lay claims for the assets are indeed who they say they are. That's the whole process of probate. To make sure heirs who claim to be heirs, living heirs of the person who died, are in fact heirs. Who can be an heir? That's coming up. So, probate or administration is a legal process by which a court determines who inherits the property of a deceased person and what the assets of the estate are. Either an executor or an executrix, you have to name in the will. If you do not name an executor or an executrix in a will, who would be in charge of making sure your final wishes are carried out and assets distributed according to your wishes, an administrator will be appointed by the court, usually a lawyer, in exchange for 10% of the value of the estate. And if no executor is named or there is no will, valid will, that administrator and let's see, if there were no executors named in will or valid, okay, they would oversee the administration of your will. Everybody got these highlights and notes?
One sec.
Okey-doke.
Okay.
Okay. While we're at it, I might as well throw the after lunch attendance poll out there for everybody to answer. And now I'm going to change the slide unless anybody needs another second here. No. I showed you guys this before in a chapter 5. I had this list in chapter 5, but here it's really for chapter 20. These are a lot of the death terms. So I put them here. I put together this list for you. Oh, by the way, did anybody ever go and search missing money or the unclaimed property link down at the bottom here to see if they had any money owed to them or their relatives or any assets or anything? Anybody find anything? No?
No, I didn't.
Missingmoney.com or unclaimedproperty.nj.gov? Nobody found anything? Nobody? Nobody? That's strange. Usually I get, especially classes this size or bigger, you know, I've even had smaller classes than this, and people found stuff. Yeah. Periodically go there. You never know. Something could pop up on there for you or for relatives. You know, I looked up and I found relatives' names on there. Okay, so anyway, heir. What is an heir? You're a natural blood relative who can inherit belongings of the relative who died. Devise is to transfer or leave property by will upon death. Devisor is the one who left you those belongings in their will. And the devisee is the one who was named in that will to receive those belongings. Demise is a transfer of property by lease. It sounds like death, that you've met your demise, but it's not. Demise is actually a transfer of property by lease. Devise is a transfer of property by death. Okay? They sound the same, don't mix them up. Devise and demise. The one that sounds like death is not. Testate means you made a will. Intestate means you did not prepare a will. Testator is a man who makes a will, and testatrix is a woman who makes a will. Probate is a court proceeding that determines who the natural heirs are, or to determine who the devisees of an estate are, no matter if you had a will or not, and what the assets are after all debts have been paid that can be distributed. An executor is a man, an executrix is a woman that you name in your will, who you trust to ensure that your final wishes are carried out as you outlined in your last will and testament on how you want your assets to be distributed. And if you did not name an executor or an executrix, the court will appoint an administrator to take on those duties. See, I got all those terms and definitions here in one place for you on this slide. Descent and distribution. Every state has their laws of descent and distribution showing that determines who your natural heirs are, who can lay claim to your assets if you die intestate without a will. We're going to go over that in a little while. Escheat, excuse me. Escheat is when you die intestate and no heirs can be located. The property reverts to the state. So the property is sold at an auction and the money is held in a fund for 1 year, at which time their heirs can lay claim to it. And if nobody steps forward to claim it, the state gets your money from your sold property and they blow it away however they see fit. A legacy is your personal assets and property that you've amassed during your lifetime. That's your legacy. Bequests is your wishes on who you wish to get it. I bequeath to thee my vast fortune of $4 in my bank account, for example. Dower and courtesy are those ancient rights that New Jersey has, where a spouse can claim, or a spouse, can claim they have an interest in all of their spouse's assets upon their death. So dower is the wife's right and courtesy is the husband's right. New Jersey abolished the creation of any new dower or courtesy rights on May 28, 1980, a date we must memorize. Because before then, there was dower and courtesy rights, but after that date, it's simply the right of joint possession for the primary marital residence. and your spouse has to leave you at least 1/3 of the estate after May 28th, 1980. Now, missingmoney.com is for other states. New Jersey no longer partakes, but you never know. You may still find stuff in there. The federal government uses it still, as well as some other states. Unclaimedproperty.nj.gov. New Jersey pulled out of missingmoney.com and created this website. It's kind of like their own version of missingmoney.com, only for New Jersey. You can check out those websites and see if you have any money owed to you. If you're new to this class, since I mentioned that, let me pull up those links and copy them and share them with you in the chat window. Yep. Look up your name, look up your relatives' names. You may find something.
So if you see a relative's name on there, what are they? Because I just did it while you were talking.
And you find a relative's name?
But they're actually my in-laws, but they're both dead.
Okay. So did they have any heirs?
Well, they have 4 children. Yes.
Well, they may not be aware that they're heirs and they can lay claim to this. So you could let their children know that there's something that the government's in possession of from their parents that they could lay claim to claim it. You know, if they didn't have children or anything like that and your relatives, then in the pecking order, I guess you could lay claim to it as well. You know, but you really got to see who, you got to go according to it. If they died without a will or if they didn't specify who gets this stuff, you know, any heir can claim it. But if they had a will specifying who gets their stuff, and sometimes in wills we have a catch-all that everything else goes to, whoever. Well, this is everything else. They could get this. So you may want to copy that link. Do the search, click on it, and copy that link and send it over to them. Let them know. Does it say there what it is and how much it is, or do you have to fill out additional information to lay a claim?
I didn't click on it because it just says, oh, do you hit like where it says like this claim? And that will tell you.
Yeah. It may tell you what it is or how much it is, or sometimes it'll require you to fill out a claim form in order to get that knowledge. Sometimes it'll show you, sometimes it won't. I don't know what determines that, whether where it's coming from. Maybe it's coming from a bank. Maybe it's coming from their pension. Maybe it's coming from something else. I don't know. It could be a CD that matured. When my dad was still alive, I did this during class one time, and I found that there was something for my father, but it wouldn't say what it is or how much it is. So we filled out the form, and it told you.
It doesn't say what it is, but it just said there's a button it says file claim.
Okay, so you could press the button, file claim. It may just ask for the name and social security number and address. And if it does, you may be able to instantly find out what it is. Other times it requires you to fill out paperwork and sign it and submit it, so it depends on what it is. So walk through it. Take a look. You never know. Let us know.
They both had wills, so I don't know.
Yeah. Well, either way, your relatives are obviously unaware of this because this is the state's in possession of this money right now.
Oh, all right. I'll tell my husband. It's his parents, so I will tell him.
Yeah. Let him know, because otherwise they're not going to. Well, then he's an heir. He could lay claim to it. If it's your husband, yeah.
Okay.
Tell them he can lay claim to it. Absolutely. You may have something due to him that he's totally unaware of. Look at that, missing money.
Let him know.
Yeah, why not? Hey, maybe you'll get enough. You go on vacation or something, right? Or pay off some bills that are in need of being paid or what have you. Hey, maybe they got a vacation property somewhere that you were unaware of.
That would be nice.
Right? Way to God, right? All right. So that's that. Moving on. Let's get our notes here now. On page 376. Write this in the side here. See page 120, remembering legal terms, OR versus EE. Because on page 120, there's a chart, which we'll get to that in chapter 7, because we skipped forward here to chapter 20, then we're going to go back to chapter 7. So we're going to be doing this next anyway, but you should write this as a reference. See page 120, remembering legal terms, OR versus EE. Remember, I told you certain words end in OR and certain words end in EE. As long as you know what the root word is, if the word ends in OR, that's the person that's giving whatever the root word's talking about. If it ends in EE, that's what the person that's receiving whatever the root word is talking about. So I'll give you time to write that down, and then we'll go over these. See page 120, remembering legal terms. And then I put OR in capital letters and in quotes versus EE. See page 120, remembering legal terms, OR versus EE. Okay, and now we'll do the highlights. So a last will and testament is an instrument made by an owner to voluntarily convey title to the owner's property after their death. A party who makes a will is known as the testator, that's a man, or a testatrix if they're a woman. The gift of real property by will is known as devise. So therefore, the one who made a will that's leaving you the property is the devisor, and the one who's receiving it in the will is the devisee. And a gift of money or other personal property is by legacy or bequests. Now, in New Jersey, children can be disinherited, so be good to your parents. But you should be good to your parents anyway. Don't expect anything from them. You know, they wiped your snot and wiped your butts when you were a baby. You know, you should love and take care of your parents now that they're older. Now they may not be able to take care of themselves no more. You know, so in New Jersey, children can be disinherited, but a surviving spouse is entitled to at least 1/3 of the estate, and the determination of the augmented estate is a complex calculation. In a case where a will does not provide the minimum statutory inheritance, the surviving spouse has the option of informing the court that they will take the statutory share rather than any lesser share that had been provided in the will. This practice is called the right of election and is reserved only for a surviving spouse. A will differs from a deed in that a deed conveys your present interest during the lifetime of the grantor, while a will conveys no interest in the property till after the death of the testator. To be valid, let's highlight, a deed must be delivered during the lifetime of the grantor. Yep. Because when does the transfer of ownership take place? Upon delivery and acceptance of the deed itself. Deeds must be signed by the seller, but they don't need to be dated or signed by the buyer, and it'll still be valid. Yeah, I usually talk about a story about some Motown diva in New Jersey who was selling her property, and you know all this stuff was on the phone. You know, documents were FedExed to her house, and she'd sign them and then FedEx them back to the attorneys and everything. They would have phone conversations, conference calls with the buyer, the seller, the attorneys. And so she was about to close up the deal on selling her property. And all she had to do was FedEx the final documents that are signed over to the other side. And she dropped dead before that could be done. And now this ended up in a lawsuit because her children were kind of greedy. And they wanted to keep the house, even though the buyer already wired the funds into her account. You don't get to keep both. It's one or the other. You either get the money and get the hell out, or you keep the house and you give the money back. You know, so that ended up being some kind of a lawsuit thing because the argument was, well, she signed the deed, but she didn't deliver it yet. Well, the thing is, she was on a conference call with the attorneys and the buyer, and she said she was on her way out the door to deliver it. She was going to drop it off at the FedEx. And that never happened because she had a stroke and died. Okay. So did the transfer of ownership take place or not became the question in the court of law. And actually the court ruled, yeah, it did take place because she signed it and dated the deed, and she had the buyer named in it. It was in a sealed FedEx envelope she was about to mail. She was on her way to mail. Even her kids didn't dispute that. But the argument was, yeah, but she didn't deliver it. Well, the intent there was to deliver. And both the buyers, her as the seller, seller's attorney, and the other side's attorney and the buyer were all in a conference call that in agreement that that's what she was going to do. So they actually ruled in favor there. So the kids got the money, but they had to get the hell out of the house, and the new guy got the house. So the transfer of ownership did take place. The property was sold. Yeah. Look it up. I'm not sure. I forget who it was that happened to, but it was some Motown diva that happened to. Okay, let's get the next thing. Remembering legal terminology, OR versus EE. This is that chart that we're going to see in chapter 7 that we will highlight. You don't got to go there now. We'll be going there after this. But this just shows you, as long as you know the product, I refer to it as the root word. Devise, what is that? When you die, you leave property to someone by devise, right? So the devisor is the one who's leaving you that property. The devisee is the one that's receiving it. You grant your ownership anytime you sell a property. So the grantor is the seller, the grantee is the buyer, or if you give it away. Legacy is your personal property that you're leaving behind. So the legator is the one who's giving that personal property. The legatee is the one that's receiving it. A lease is a document where an owner of property intentionally conveys their all their rights and interest in that property, as well as the possession to a tenant for a limited period of time, is defined in this document we call a lease. So who gives the lease? The lessor, the one that ends in OR. And the one who gets the lease is the lessee. So who is the lessee? That's the tenant. The lessor is the landlord. Now, what is a mortgage? The mortgagor is the borrower. I could say this over and over again, and you guys will still get it wrong. Hopefully you don't. A mortgage got the little asterisk next to it. It's the opposite of what most people think it is. Anybody here know what a mortgage is? Down the bottom, there's an agreement. There's a little explanation of what a mortgage is. A mortgage, when I ask people what a mortgage is, a lot of times people say it's a loan. And no, it's not. A mortgage is a promise to pay. You could get a mortgage loan. A mortgage loan, there's two words there. The loan is the money. The mortgage is your promise to pay it back. So who makes a promise to pay? The borrower makes the promise to pay. In exchange, the lender will loan you their money. So what is the promise that's being made by the borrower? They're saying there's two parts of a mortgage, the mortgage and the note. The note is the financing instrument that lays out all the terms of repayment. How much did I borrow? What is the interest rate? What is my monthly payment? When are the payments due? How many payments do I got to make? Okay. And the borrower makes the promise to follow those payments, all those agreements. In exchange, they say, if I fail, the mortgage is your promise to pay that says, if I fail to pay back the money as outlined in the note, the borrower can foreclose on me to regain ownership of the property pledged as collateral for the loan. sell it at auction, and use those proceeds to pay off the debt. That's what a mortgage is. It's the promise to pay that's making that as the promise. I promise to pay back the money, or you could foreclose on me, sell it at auction to get the money back to pay off the debt. That's what the promise to pay is. So that's what a mortgage is. A loan is money that's given to you by a lender. Okay. The mortgage is the promise to pay that money back. So therefore, the one who gives that promise is the mortgagor. The part where people mix it up is they misconstrue that with the person who's giving you the loan, the money, because they think of a mortgage as the money. It's actually the promise to pay. So you got to either remember that whole entire story and remember who the characters are, or just keep it simple and sing it like I do. The mortgagor is the borrower. Hard to forget, right? Who's the mortgagor? The borrower. Come on. It's a little rhyme. It kind of rhymes, right? The mortgagor is the borrower. Hopefully, my annoying voice gets stuck in your head so that you remember it come exam time. I doubt they're going to give you a straightforward question on exam like, who is the mortgagor? Oh, the borrower. But they'll probably give you some long-winded question that has the word mortgagor and mortgagee and mortgage in it. You know, so you got to remember the definition and who the players are to understand what the question is asking from you. That's how they trip you up. You know, because they have all these terms in it and you may not remember, oh, what does that term mean? You know, and now you get screwed up and you don't understand what the question's asking of you. But because especially if you're thinking of the mortgage or as a loan, it's a promise to pay, you know. So therefore the mortgagor is the and the mortgage does not rhyme. It's a lender. Okay, so you can also write here next to mortgagor, borrower. And remember that mortgagor has 2 O's in it, and the word borrower has 2 O's in it. And the word mortgagee has 2 E's in it, and the word lender has 2 E's in it. Here's another way to try to remember it. For me, I like to keep it simple, stupid, KISS concept. You know, the mortgagor is the borrower. Don't make me think. That the singing is an easier way to remember it. All right, that works for me anyway, whatever. But you guys could see it works the same way with all of these terms. As long as you know what the root word means, the ones that end in OR is the person that's giving. The one that ends in EE, that's the word, that's the person who's receiving. Okay. Don't worry, we'll have this graphic up again in chapter 7 where you could do the highlights and write these things next to it. In the meantime, let's see what the legal requirements are for making a will. Anybody here have a will? Or anybody here do not have a will? So nobody here has or does not have.
I have one.
There you go.
I don't
Anybody
know.
else have a will?
Nope.
You all think you're invincible, right? I'm going to live forever. I know. Listen, I was there with you for the longest time, but you know, you never know. You know, and you know, I got a senior mom, I got a brother, I got a sister, I got nieces. You know, I put together a will. You know, I'm not getting any younger. You know, so time to put these things in order because you never know. Even if you just write it down. If you completely write it down, this is known as a holographic will. It's a handwritten will, and they require no witnesses to be valid. Okay. Now, you need to be at least 18 years of age in order to be and of sound mind. You got to be at least 18 years of age, and it has to be a free and voluntary act. Nobody's forcing you to do it to create a will. Okay. Devising how you're going to dispose of your assets. And the general rule is that a will must be witnessed by 2 persons. And someone who's a beneficiary of a will can serve as a witness in New Jersey if the signatures are witnessed and notarized within 2 days. Now, a holographic will is just simply a completely handwritten will. You don't print it and then sign it. The entire will is handwritten. That does not require any witnesses. Now you may be thinking, well, I like selfies. I'm gonna video myself saying who gets my stuff. That's not legal. It's not valid in New Jersey. Okay. If you want, you could do this. You can make a video will, but you should have it also written down, and they should not contradict each other. Okay. Wills must be in writing. Video wills are not valid. You could add them for the dramatic flair if you like, telling, hey, you get this, hey, you get this, and for you, nothing. I wrote you out of the will because I never liked you. Okay. You could do that kind of a thing if you like, just for drama. But either way, then we also have, for real property acquired by married persons before May 28, 1980, they got those dower and courtesy rights. So the surviving spouse is still entitled to a life estate of 1/2 interest in all real estate owned by the deceased, no matter what other provisions were made in the will. They're entitled to half the estate if married before May 28, 1980. Oh, wait. For property acquired by married deceased persons before May 28, 1980. Okay. Any property acquired after May 28, 1980, your spouse only has the right of joint possession, which is the primary marital residence. So, title to real estate and personal property of a person who dies intestate passes to their heirs under the descent statutes, and the primary heirs of the deceased are their spouse, civil partner or domestic partner, and close blood relatives. When children have been legally adopted, okay, listen, we're going to talk about this a little bit. We're going to make some comments. It's not meant to offend anybody, but you just got to understand how this works. A lot of these laws sound like they may be medieval, and that's because they were written a long time ago, and the law still works the same. Okay, so when children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. Okay, so in other words, if you are adopted, you could inherit from your adopting parents, but not from their side of the family, their brothers and sisters, which would be your aunts and uncles. You cannot claim to be inherit from them because you're not truly a blood relative. Okay. It works like lines of successions with like kings and queens and emperors. You can't lay claim to the throne if you're not really a blood relative. It works kind of the same way with your assets here. Now they could write you into their will and leave you stuff, but we're talking about what happens if they die without a will. You can't claim that you're an heir. Okay. Only you could do that for your adopting parents, but not from their sides of the family, their relatives. Okay. So in most states, illegitimate children, okay, let's stop right there. That sounds pretty harsh, doesn't it? What's an illegitimate child? An illegitimate child means that your parents were not married when you were born. And that applies to a lot of people, even people who their parents ended up getting married. If your parents were not married when you're born, here, let me put it in Game of Thrones language. You are the bastard child. Okay, that's how they referred to it in the movies. So in most states, illegitimate children, they inherit from the mother, but they do not inherit from the father, unless he admitted to being your parent in writing, or parentage has been established legally in some other way, whether he did it in writing or through a blood test or something. If he legally adopts his true blood relative child, that child then inherits like an adopted child would from the father, but not his side of the family. Now, this doesn't make sense to me whatsoever because you're actually a blood relative of his side of the family. So I that kind of doesn't make sense, right? But that's the way the law is. Not a problem with it. Tell our politicians to fix it. Although they're not good problem solvers. All right, now, Intestate real property is distributed according to the laws of the state where the property is located. In New Jersey, a law of descent distribution provides that real property belonging to an individual who has died intestate is distributed in the following order. The law and the estate discussed apply only to what remains of the estate after all payments of debts. All your taxes have been paid, any debtors have been paid back. So this is how it works. And remember, this only comes into effect if you die without a will. Because if you die with a will, it goes according to your wishes in your will. But if you don't die with a will, how do we figure out who gets your stuff? Well, it goes according to this. A surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. If there are children, if there is a child or children who are also children of the surviving spouse, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves parents and a spouse but no children, the spouse or partner receives the first $50,000 plus 1/2 the remaining estate. The rest goes to the parent or parents. If there are children who are not the children of the surviving spouse, the spouse or partner receives half the estate and the child or children the other half. And where no spouse or partner survives, children become sole natural heirs. And where there are neither surviving spouse nor children or children's own heirs, the estate goes first to parents and failing that to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. But beyond that, the entire estate goes to the state of New Jersey by escheat. Okay, so how does that escheat process work? Well, the state treasurer sells the property at a public sale, giving notice by publication in newspaper in Trenton and whatever the major newspaper is in the county where the property is located. The proceeds of the sale are held in a fund for 1 year, and if no claims are made within the year, the funds belong to the state. They go to the general fund, and the state blows your money however they see fit. So that's what happens when you die without a will. The state gets it, if no natural heirs claim it. You guys you guys paid taxes all your lives, right? And you want the state to get all your stuff when you die? Write a will. Because if nobody steps forward to claim your stuff, the state will get it. Plus, it streamlines the probate process, so probate goes a lot smoother if you have a will. Otherwise, it could drag out and it could take a while, that process. You know, even if it's obvious, the only survivor is a single child that you had, right? It's obvious that they're the only sole heir that's entitled to everything, right? They're the only one alive. They're entitled to everything. If you didn't have a will, it's still got to go through probate and the process can be drawn out. Then they'd have to appoint somebody as the administrator who gets 10% of the estate for administrating it. You know, it's BS. Write a will. Everybody here should have a will. Just like if you get married, you should have one of those, what the hell did I call it before? Prenuptial agreements. You need a prenuptial agreement more if you're poorer than if you're richer. Because it's nothing for a rich person to say, here's $1 million, get out of my life, go away. But when you're poorer, I'm not just poor, I'm talking about like moderate income too levels. You know, when you if you get divorced, it's it'll make you broke. The attorneys are the only ones that get rich during those things. I know, I got a friend right now, she's getting divorced. Even her assets were frozen. I had to lend her money to hire an attorney. It's crazy. Okay. That concludes chapter 20. Let's do key terms to review for chapter 20 now. I think there's only one key terms in chapter 20. Tell you once I get there. Okay. Yeah. So next to letter L, before we get started, next to letter L, at the end of the line, after where it says inherit, one who can inherit, right? Blood relative. And then next to number 5 on the left-hand side, we're going to make some notes here on the left-hand side. Next to number 5, where it says executor, put a slash and write executrix. It's spelled EXECUTRIX. 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 And then go down to where number 12 is, where it says testator. Put a slash and then write testatrix. Testa, T-E-S-T-A, testa, trix, T-R-X, T-R-I-X. Testatrix. It's pronounced testatrix. I guess you can pronounce it however the hell you want. Testatrix, testatrix, whatever. T-E-S-T-A-T-R-I-X. Now we could do the review, the key terms. Person named by the state to administer a descendant's will. What do you call the person that's named by the state to administer a descendant's will?
Administrator,
Yes, it is. One is A. Court proceeding to establish the validity of a will.
probate,
Probate, 10 is B. Title acquired by usage. What is title? It means ownership. I'm sorry,
adverse, adverse possession,
correct. 2 is C. Person named in a will to administer a descendant's estate.
executor,
Executor or executrix, right? Because they're gendered. So executor if they're a man, executrix if they're a woman. 5 is D. Transfer of title without the grantor's consent.
Involuntary alienation.
8 is E, involuntary alienation. 8 is E, correct. Without a will.
intestate,
Intestate. 7 is F. What do you call a person who makes a will?
testate,
Testator or testatrix. 12 is G. A document disposing of property after one's death.
Last will and testament.
Yep, 9 is H. Having made a will.
Testate.
Testate. 11 is I. Acquiring of property by natural heirs. We just went over the whole process. Acquiring of property by natural heirs. Well, they figure out who your descendants are, so it's descent. 3 is J. One who receives property through a will. Who receives property through a will?
Here.
Through a will.
devisee,
A devisee. 4 is K. One who can inherit, those blood relatives who could lay claim to your estate when you die without a will. They can make claims.
Heir.
That's an heir. 6 is L. Transfer of title with the grantor's consent.
Voluntary alienation.
Voluntary alienation. 13 is M. Okay. And that concludes chapter 20.